Ryan Brown here. Today we're going to talk about possession with the intent to distribute. It's a drug crime in Georgia. It's kind of between a simple possession or sale case and trafficking. We have possession with intent there in the middle. We're going to go over what prosecutors have to prove to secure a conviction for possession with intent, some of the evidence they typically use to prove their case in these situations, and sentencing ranges for a conviction. So possession with intent is kind of a unique drug crime. They have to prove a mental state of the defendant, but that's not all they have to prove. So essentially, any drug crime can be the predicate. If someone's possessing drugs, selling drugs, manufacturing drugs, trafficking in drugs, whatever it may be, that can satisfy this first element of possession with intent. In addition to that, however, prosecutors must prove that the defendant was doing that. So they were possessing those drugs or making those drugs with the mental state, with the intention to distribute them. Okay, so that they're possessing, the most common we see is that they simply had possession of the drugs and with the intention that they were going to sell them, distribute them, give them away, whatever it may be. The unique thing about this is, in a drug possession case, the prosecutors and the law enforcement officers are focused on how much drugs there were. What is the quantity? How much cocaine? How much methamphetamine? How much marijuana? The weight is what is so important. With possession with intent, there's no weight element. So this is something that prosecutors use to turn a misdemeanor amount of marijuana into a felony. So you may have less than an ounce of marijuana, but sometimes if you have it packaged separately, or we'll go over some of the evidence later, they can turn a half an ounce of marijuana, which simple possession would be a misdemeanor, into a felony possession with intent, and prosecutors love to do that because they love putting people in prison. So let's talk about sentencing guidelines the sentencing laws here in Georgia for convictions of possession with intent. So it depends on which drug we're talking about. So Schedule 1 or 2, your more controlled, more serious drugs, your sentencing range for a first-time conviction is going to be 5 to 30 years. So up to 3 decades in prison for a first-time conviction for possessing a Schedule 1 or 2 drug with the intention to distribute it. It's kind of small here, but the sentencing range increases upon a second conviction, or third or fourth, or fifth, sixth, whatever it may be, for possessing a Schedule 1 or 2 with the intent to distribute. It increases up to a minimum of 10 years, a maximum of 40 years in prison, or even life imprisonment for a conviction for those crimes. Finally, in regards to sentencing, a possession with intent crime for a Schedule 3, 4, or 5 drug, the range is significantly lower. It has a minimum of 1 year and a maximum of 10 years in the state penitentiary. Finally, let's talk about some common evidence that prosecutors use when they're proving possession with intent cases, or trying to prove. We're trying to prevent that, obviously. They love having individually packaged drugs, and this kind of goes back to the misdemeanor amounts of marijuana. Let's say you have a half an ounce of marijuana, but it's split up into 4 or 5 different mason jars or something like that. That is evidence that prosecutors love to say, look, this is individually packaged for sale. Plastic baggies, they love the saran wrap, the little small plastic baggies. They say, hey, that's how people package drugs. If you have them, you must be selling drugs. Cell phone, they love going through people's cell phones. There's another video I have about should you give your password to the cops if they get your phone. The answer, of course, is no. You should never talk to the cops about anything. It's bad. They're not here to protect you. They're here to arrest you. Even if cops get a search warrant for your phone, they can't compel you to give them the passcode. They can't make you talk. You have the right to remain silent. So often people get so scared with that search warrant for the phone that they start spewing the passcode. Just use your rights. Be quiet. Don't talk. They love going through your cell phone, seeing who you've been texting about what. 2 more. Cash. They love having cash. If you have cash on you, they just assume that it is from drug transactions. Finally, admissions. Hey, man, it's better if you come clean. What were you going to do with this dope? Somebody goes, oh, I was going to sell a little to my buddy. You just confessed to possession with intent. Don't ever do that. I've seen it happen. People do it all the time. They think, oh, if I just come clean, this cop's going to tell the prosecutor, who's going to tell the judge, and it's going to make my life easier. That's not true. That's not how it works. Keep your mouth shut. Okay. This is possession with intent. Again, Ryan Brown, J. Ryan Brown Law, representing people accused of crimes across the entire state of Georgia. You can call us or text us anytime, 470-635-1725. Website is jryanbrownlaw.com.